Good evening and welcome to our WebEx session, How COVID-19 Will Impact Corporate and Individual Tax Residency. The session will be presented by Mr. Nishith Desai, Ms. Parul Jain, Mr. Ashish Sodhani. Please note that this session will be in listen-only mode and will last for about 60 minutes, out of which 30 to 40 minutes will be spent on panel discussion. The remaining time will be available for Q&A. Requesting all the participants to be on the mute mode for the session. You can now post your questions in the chat window while the panel discussion is on. The moderator will queue up the questions for speakers accordingly. Should you need any assistance during the conference call, you can use the chat option. Do note, this conference is being recorded. I now welcome our session presenter, Mr. Nishith Desai, founder Nishith Desai Associates, Parul Jain, who co-heads our tax practice at Nishith Desai's Delhi office. She is a lawyer and a chartered accountant by profession. She has close to 2 decades of experience in corporate and international tax field and specializes in M&A transactions and private equity space. Ashish Sodhani focuses on globalization and externalization of corporate transactions and regularly represents clients before various forums, including tribunals, various high courts, and Supreme Court of India in relation to disputes on international tax. I now request all the participants to put their lines on mute mode. Over to you, Mr. Desai.
Yes, good evening to everybody here in India, in Singapore, and as far as the Western world is concerned, good morning and good afternoon, depending on the jurisdictions in which you are. But thank you for joining in numbers. Really delighted to have you. And it's a very interesting subject that we're going to discuss with regard to the tax residency of the individuals and the corporates, especially in the context of COVID-19. It's very important to understand that the whole landscape for the definitional context of the residency has undergone significant change in the last couple of years. And in fact, as far as individual tax residency is concerned, the definition was more simple. Now it has become slightly more complex, and the same thing with corporate. And both have become more complicated than ever before. And as far as corporates are concerned, it's even more complex because of the subjective criteria that has been incorporated. So at one point of time, the corporate tax residency was linked to central control and management, and now it is connected with ratio effective management. I think there is slight difference in nuances. And, Parul will be explaining to you the definitional context, and Ashish will get into the individual tax residency. So basically, as far as the taxation is concerned, tax residency goes to the core of the whole subject. And as you all know, the tax residency and the source are the two main factors that connect and create tax liability or exempt them from tax liability, whichever you want to look at it. And so I think today what we want to do is to look at how COVID is also going to impact the circumstances relating to the tax residency. Because some of the circumstances, usually you are able to plan when to be in India, when to be outside India, where to hold board meetings, where not to hold board meetings, stuff like that. But now you are all locked down, and that's causing some issues, and how other countries have looked into that also we'll be looking into. So just to get back to basics, I think some of you may or may not be fully familiar with the concept of tax residency in India. And what I would like to do is to request Parul and Ashish to explain the basics of taxation and tax residency, and then get into the situation that COVID is creating at this point in time. And I hope government recognizes those circumstances beyond the control of a company or beyond the control of the individual, and should grant some relaxations in terms of tax liability that may arise. But let's move on, and may I request Parul to start with, and over to you, Parul.
Yeah. Thanks, Nishith Bhai, and thanks everyone who all have joined us, for this very interesting session. I'll start with the concept of residency, and like Nishith Bhai mentioned, the concept of residency is really at the core of taxation, where India is concerned. It really depends upon the residential status of the person, be it a corporate or be it an individual, with respect to how taxes are levied and how India treats benefits to be granted under tax treaties as well. Till 2015, tax residency of companies was dependent on where the entire control and management of the company was situated. Now, just generally, this created certain issues from a tax authority's perspective because, even if one board meeting was conducted outside India, one could take an argument that the entire control and management is not situated in India for the foreign company. And so, therefore, the foreign company should not be considered to be a tax resident of India. This coupled with, the fact that under most of the tax treaties and as an international concept, place of effective management is a concept which is generally used for determining tax residency of persons other than individuals. And hence, the government thought it wise to amend our Income Tax Act from 2015 to state that a company will be said to be resident in India in any tax year if either it's an Indian company or its place of effective management in that year is in India. So, of course, if it's an Indian company, then it doesn't really matter whether the place of effective management is in India or not. It will deem to be a tax resident of India. But if it's a foreign company, then the place of effective management will need to be determined for looking at the residency of the foreign company. Now, this was actually a bit of a flip-flop that happened between the CSC rules and the POEM rules. Initially, there was a lot of talk about implementing the controlled foreign corporation rules in India, by which foreign companies which are completely controlled from India, by way of a shareholder control, they would be subject to tax in India provided certain parameters, example, passive income and control, more than 50% control in India was met. The POEM law was primarily introduced with respect to such offshore companies and for companies which are owned by Indian residents. However, the impact is much larger because even for other foreign companies which are, for example, investing into India or who are doing some sort of business in India, they would need to evaluate their residency to determine, whether the place of effective management is in India or not. So what really is place of effective management? Place of effective management has been defined to mean a place where key management and commercial decisions which are necessary for the conduct of the business of an entity as a whole are in substance made. Now, I'll just pause here for a while because this definition has a lot of attributes. At one point in time, it talks about key management and commercial decisions. At the second hand, it talks about conduct of the business of an entity as a whole. And what this really leads us to, conclusion is that it's not the day-to-day or the operational decision-making that's really necessary for determining whether a POEM is in India or not, but it's primarily the decisions, the key management and the commercial decisions which are required for conducting the business of the entity on a wholesome basis, which will determine where the POEM is. And of course, the definition also has a very important aspect of substance. And there were some guiding principles which were introduced to determine what should be kept in mind for a determination of a poem in India. And the guidelines have reiterated more than once that the concept of poem is more about substance over form as compared to form over substance. And in substance, where the key decisions are really being made, that is going to be the place where the poem will be said to be situated in India. The establishment of poem depends on whether the foreign company is engaged in an active business outside India or whether it is not engaged in an active business outside India. The concept of active business is with respect to whether the company has, it has passive income of more than, of not more than 50% of its total income, and less than 50% of its assets and employees are situated in India. So mostly, if a foreign company has passive income, then it will not be considered to be engaged in active business outside India. But if it has active income, then the determination of its poem is different from a company which does not have active business outside India. For a company which has an active business outside India, the place of effective management is actually presumed to be outside India if majority meetings of the board of directors of the company are held outside India. Now, this is really important, given the times that we are sitting in, locked in our houses and, without really meetings happening in a physical form. We saw that even in the Indian context, now Indian companies are being allowed to conduct their meetings over video conferences and audio conferences. And so the manner in which these meetings are being conducted for a foreign company will need to be really looked into to see whether a poem can be said to be India, especially since for companies which are engaged in active business outside India, the place of effective management can be presumed to be in India if the majority of the meetings of the board of directors are said to be outside India. We'll also have to look at this over the entire year. And what the guidelines also state is that while an entity can have more than one place of management, but it can only have one place of effective management at any point in time. This is really important because this is a distinction between place of management and place of effective management. And this is where, one will really need to evaluate what is the quality and what are the type of decision making that are happening in India during this period of time when decisions may be made out of homes and over, conference calls and over, over VCs. With respect to companies which are not engaged in active business outside India, or talking more about companies which which earn more of passive income, and these could also be private equity investors who are investing into India. There is a two-pronged approach for determining their poem in India. The first step is to identify the people who are making the decisions. And the second step is to identify the place from where these decisions are being made. There are, of course, some guiding principles which are being given for determining, where those key people are based and where the decision making is happening. We won't really go into really intricate details of those. But most importantly, there are, even in the guiding principles, there is an acknowledgement that given the technology that's operating in today's world, it is possible that members of senior management may operate from different locations, and people may participate in meetings via telephone or video conferencing rather than being physically present at meetings in a particular location. In such a situation, the place where the poem would be regarded would be where the highest level of management is located. And when we talk about the highest location of highest level of management, This would mean, the managing director, the people who are in charge of calling the shots for the company, the CFOs, the CEOs of a company. That's where really the decision making will be regarded to have taken place. Another important aspect is that the operational decisions with respect to oversight of day-to-day business activities and operations of a company are not so relevant. What is important is that broader strategic and policy decisions need to be taken in the meetings which are to be considered for determining whether place of effective management is situated in a particular jurisdiction or not. There are certain secondary factors also, and those are, where is the main and substantial activity of the company being carried out, and where are the accounting, where really are the accounting records of the company being kept. This is more, more on the technical aspect of, how India really looks at determining corporate tax residency. There is also a threshold of about, rupees 50 crores or approximately $7 million that if a company does not have a turnover of gross receipts higher than this amount, then in that case, the POEM rules will not apply. There are also, different rules which exist for determination of income in case if a foreign company is regarded to have a POEM in India. But we'll talk about that a little bit more as we move along. I think, Ashish, over to you. Let's talk about how, individuals are subject to tax in India. Because, while we talk about corporates being subject to tax in India and forming a POEM in India, ultimately it's these individuals who are creating that tax risk for the foreign companies. So how would individuals really be looked at from a tax residency perspective, given this whole, issue also that arose on account of stateless people and stateless income? Maybe you can throw some light on that.
Sure, Parul. Thank you very much. So I think like what Parul and Nishith have been saying, that residency is the core to income tax in India. And if you're a resident in India, then it depends upon what kind of resident are you in India as an individual. Because depending upon the type of residency that you have in India, your income becomes subject to tax. The income could be either Indian sourced income, or it could be your worldwide global income that could be taxed in India. At the very outset, to become a resident in India in any particular financial year, that is between 1st April and 31st March, if you have stayed in India for a period of 182 days or more, you should be considered to be a resident of India for that year. Apart from that, if you have stayed in India 60 days and 365 days in the preceding 4 years, preceding the last year, then also you would be considered to be a resident of India. This would result in your Indian sourced income becoming taxable in India, and if it is earned from any business or profession in India. This is the basic two tests that need to be kept in mind while determining your residency. However, there is an exception to the rule where if you have spent 60 days in India in the last year and 365 days in the preceding 4 years preceding the last, in such a case, if you are visiting India, then this test says that the 60 days will be replaced by 182 days, which means you could spend 182 days in the last year, and in the last 4 years preceding the last, you could spend 365 days in India, and only then will you become a resident of India. Now, this test has undergone some changes where they say, where the Finance Act now has provided that if you have income from Indian sources, which is for more than 15 lakhs, INR 15 lakhs, in that situation, the 182 days will be read as 120 days. So that means if you spend time in India for 120 days in last year and had income more than 15 lakhs and 365 days in the preceding 4 years preceding the last, then you would be considered to be a resident in India, and your income would become subject to tax in India. However, if your income is less than 15 lakhs, then the 182 days will stand. This is a significant change, considering that in most countries the number of days threshold is 183, but India has reduced this to 120, thereby making it difficult for people who are visiting India to spend more time in India and not become a resident. Uh, the other change that has been brought about is with respect to stateless persons. Now, stateless persons, when we call stateless persons, what basically India is trying to do is that if there is any individual PIO uh, 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 who is not paying tax in any country around the world, then in that situation he may become an Indian tax resident. So the new section provides that that those citizens not liable to tax in any other country by reason of their domicile or residence or similar criteria shall be deemed to be tax residents of India. So if you are a stateless person, if you are traveling around the world and you are not liable to tax in any other country, then by default you would be considered to be a tax resident of India. Now, this has gone through a lot of debate. There was a lot of hue and cry when this provision came up in the finance bill. And now, when the Finance Act has been passed, they have made a small change to this provision and said that if your Indian sourced income is more than 15 lakhs, and you are not liable to tax in any other country, then you would be considered to be a tax resident in India. So they have added a monetary threshold for becoming taxable in India. Uh, but the important point here is that you need to be liable to tax in any other country for you to not be considered to be a tax resident of India. Now, liable to tax has been interpreted in many ways. One way to look at this would be that even if you are not subject to tax in the foreign country, but are still within the scope of taxation of the foreign country, you should still be considered to be liable to be taxed in that foreign country and therefore not be considered to be a tax resident of India, and therefore this provision should not be applicable to you. It's quite interesting how this plays out because liable to tax is a debated term, the debated expression, and we'll have to see how courts look at it and what will be the final outcome of liable to tax. Uh, Coming to the next change, this is with respect to residency of individuals who are resident but not ordinary residents in India. So, like I said, for you to be a resident of India, there are various residency criteria, right? The What I spoke about were the 182 days and the 365 days. Here, I would also talk about when you are a resident and not ordinary resident in India. Now, in such a situation, the law that currently stands provides that if you have been a non-resident in India for 9 out of 10 years preceding, in 10 years preceding that year, or out of the 7 previous years, you have been in India for a period of 729 days or less, you would be considered to be a not ordinary resident of India. Now, there has been an addition to these changes, which provides that who sorry which essentially provide that if you have income of more than 15 lakhs and have spent 120 days in the previous year and 365 days in the previous 4 years preceding the last year, you would again be considered to be a resident and ordinary resident. And if you are a stateless person who is not liable to tax in any other foreign country, you would again be considered to be a resident but not ordinary resident, and you would be subject to tax in India with respect to your Indian sourced income and income that you are earning from profession or business in India. These are effectively the changes and what the residency looks like now and how it has evolved from what it was earlier. With respect to dual residency, I think the point that comes in is if you are a resident of a foreign country and you become a resident of India, how will it all play out? Uh, this goes back to the tax treaty that India has signed with that country, wherein we have to now look at uh, where where the tiebreaker will break. So tax treaties provide for a tiebreaker test where a residency of an individual will need to be seen as per the tiebreaker test. If your tie breaks in favor of India, then you would be considered to be a tax resident of India as per as per the tiebreaker, or it could be in the other country as well. Some of the common things that we see in a tiebreaker test are: where is your habitual pod, where is the family living, where is your economic presence. All of these things become important to understand where do you exactly going to be considered to be a resident, and that's where the tie would normally break. Uh, in times like this, where it is uncertain in which country you are staying, and suppose if you are traveling and you are stuck in any other country, how will the determination take place, right? In such a situation, the tiebreaker test definitely comes into play, and your habitual abode, your economic presence, all of that factors will need to be looked at before we can consider you to be a resident or a non-resident of India. I think this was about basically what the residency is. Parul, would you like to take up some hybrid structures or Ps, how it will work out for residency for those kinds of entities?
Yeah, sure, Ashish. So let's talk about private equity investors first. And when we look at private equity funds, this is a very important time that we're talking about, because it's towards the end of March, and depending on the jurisdiction where the funds are set up, there may be a requirement for the fund manager to sign off on the accounts. There may be some, urgent meetings that may need to be done. Also, given with the economic slowdown, given with what all is happening, there may be certain strategic and business decisions which may need to be taken by companies all over the world. So, what would really happen in those type of structures? If we look at private equity structures as such, we are talking about fund managers sitting in India, let's say being stuck in India because they're not able to travel, and taking decisions sitting in India for the private equity fund. And the question that arises is that, and looking at the POEM guidelines, POEM is going to be where the highest level of management is sitting and where those decisions are taken by the highest level of management. Who really is the person who is sitting in India who is taking the decision? I think that is going to be one key aspect. What type of decisions are being taken? Are these more with respect to day-to-day operational decisions for the private equity fund, whether it's with respect to releasing funds for a new investment, or whether it's with respect to just signing off on the bank account disbursements? Is signing off on bank account disbursements, or is signing off on accounts of the company through board meetings, through virtually, is that really considered to be a key management and commercial decision? I think that's a very important question that needs to be asked. And the other question which is important is that if one meeting is also conducted from India, and that too on a virtual basis, where all the board meetings have been conducted for the fund outside India, then does that really change, change the pendulum in favor of India? Because as per the PE guidelines, it does not really matter whether, except in the case of companies which are carrying on active business outside India. But for passive companies and, private equity funds would be considered to be passive companies. It does not really matter whether majority of the board meetings are happening in India or outside India. What matters is what type of decisions are really being taken. The other part that would really have to be looked into is that when there are investments that need to be made, and this is very typical for a private equity fund. Is making of investments part of the routine business of the private equity fund, or is it more, with respect to taking a key management or commercial decision making? Now, if we look at, the way that the PE guidelines have been worded, and of course, these are more simplistic guidelines. They talk about that. Day-to-day activities do not really constitute POEM in India. But however, where a broader strategic and policy decisions, so for example, opening up, a new geography for investment or changing your investment strategy, where it really relates to policy level decision making, that is what would really consider, they would consider a poem to be set up in India, to be determined in India, as compared to day-to-day routine decision making. What also comes out of the guidelines is that a snapshot approach is not to be adopted. And so therefore, activities performed over a period of time during the entire previous year need to be considered. And hence, if just a single board meeting is taking place in India, possibly that may not be the sole criteria for determining whether a poem is established in India or not. The other important criteria that is specifically relevant for private equity funds is even if there is a poem in India, what does it really change? And is there really, any difference for funds that establish a poem in India and for funds who do not really have a poem in India? If you look at the taxation of a foreign fund in India, which has a poem in India, the capital gains tax rates remain the same as for a foreign company. In fact, a foreign company which has a poem in India is taxed at the same rates as a foreign company is taxed. The difference that comes up is one for grandfathered investments, and this is for funds who have invested through treaties like Singapore or Mauritius, and their investments have been grandfathered. For grandfathered investments and exit of investments, it would be difficult to take treaty benefits. Treaty benefits may not be available for a fund which has grandfathered investments in India. And secondly, for funds who are operating on a global basis and who have a global investment policy, the risk for covering the entire portfolio and making the entire portfolio subject to tax in India would be quite high. So this would be a tricky time when decisions would be taking place in India. We've also seen, based on our experience, that more so a lot of people would be traveling to to different countries where strategic decisions need to be taken place, or sometimes the way private equity funds also operate is that when an investment decision is made, or if there are some very relevant decisions that need to be made, there is a lot of travel that gets involved, and the decisions are usually taken place outside India. So there would be a very big question mark on on decision making happening in India at during this time, especially as more investments are being made. And it is not just going to be for this financial year, but also for the next financial year, because possibly people are going to be stuck in places where they are for the next financial year as well, for a part of the next financial year. So even the next financial year may come into a bit of a question mark where tax residency of these of these corporates is concerned. If there is a poem in India, then one may also have to evaluate how the other country is looking at is how other country is looking at establishment of a poem. So, for example, if a fund is based in Singapore, then is your residency in Singapore or is it in India? Again, the tiebreaker would come into effect, and the question that really comes up is, can you really have two places of effective management for the tiebreaker to be invoked?
Sure, Parul. Thanks for that. So I think we've all understood that poem can be absolutely confusing and really complicated, to understand, and it's really subjective upon how and what is happening to determine what the poem of the company can be, whether it will be in India or whether it will be outside. Now, I think this brings us to another set of questions, or another question that we often see, where there is an Indian parent with a foreign subsidiary. Now, in situations like this, how will poem pan out, right? Because would it be that the Indian board of directors, in the parent's board of directors, are also the board of directors in the subsidiary company which is outside, and therefore deeming the foreign entity to be an Indian resident by virtue of the poem, or will a part of these suppose execution level stuff is being given to the parent entity which is doing the board of directors is doing some part of that for the subsidiary. In that situation, does the poem of the subsidiary become the parent in India? I think be good to know some thoughts about that.
Right, sure. So, the good part is that there are also some guidelines with respect to, the poem for in a parent and sub situation. The mere fact that a foreign company is completely owned by an Indian company is not just a conclusive evidence that, poem should be established in India. Nor is it that, if one or some of the directors of the foreign company reside in India, should be regarded as a conclusive evidence that poem in India has been satisfied. If certain decisions are being taken by the parent company for its foreign subsidiary in India, I would still look at, the entire year to see what really has happened outside India, because at least for companies which are engaged in active businesses outside India, there is a presumption that, poem would be in a place where majority of the meetings are held, provided that the company's board of directors have not really stood aside. And, when we talk about standing aside, we are really talking about, that they are not just rubber stamping any decisions which are being made by a parent company. They're actually making the decisions themselves. However, where in a situation like this, if the board has de facto delegated its authority to make, its key management and commercial decision making to its parent company, and it does nothing then, more than just ratifying such decisions, and this is being done throughout the year, then I would be quite worried. I would say that one sole decision being made in India by a parent company in the COVID times is not something really to worry about. But we would really need to look at the entire year to see if that is an approach which is being followed on a consistent basis. I think we also have a question on the chat box, on this issue, that whether corporates, whether there is any tax restructuring that is possible due to COVID-19. And if yes, then what shall be, what should be advised? So at least, I think on the tax restructuring part, of course, we can't really move around. We can't really, take decisions outside India. But if decisions are being taken over a VC or an audio call and, people are spread across countries, then the risk probably would be low. But if people are sitting in India and there are decisions which are being taken, unless and until those decisions cannot be deferred, there's not much that can be done. I don't know, Nishith, do you have a view on this, on, what can really be done? We are sitting on the 27th of March. Is there anything that can be done to, mitigate the risk of a poem in India?
No, I think you're right on the point, because the law is not giving or carving out an exception for exceptional circumstances under which such decisions have to be taken, and it is very important for government to come out and give some clarification that those who are stuck for uncontrolled reasons in India, then they would not be adversely affected. And this will require a lot more articulation in the law as well, because one thing is to decide in principle, but the bigger problem we often find is how the amendments are drafted. So, it is very important that, first of all, to recognize that there is no particular exception for exceptional circumstances under which such decision is taken, And number two, if the foreign company becomes tax resident of India for the reasons that we just discussed, that, some important decisions are taken. In fact, if the foreign CEOs or the board members are in India for any reason, and they're stuck in India, there's no way they can fly out. So they are in India. And during COVID, lots of major policy decisions will have to be taken from India by definition, whether it's employment related policies, whether it's corporate governance related policies, or, a number of things. So many things have to be done because of the, because of the situation. So obviously, tax department would come and say, oh, all the major strategic, important decisions, critical decisions that they come from India, and therefore these are tax resident in India. So what next? The next thing then, we'll have to really embark on this tie-breaking rule, and depending on the treaty, that if there's no treaty, you are stuck a little more. If there is a treaty, then both countries can sit together and figure out how to resolve the issue. But it will be more advisable for people to recognize that this situation will arise. One of the things I would strongly recommend is that whenever any such exceptional circumstances have happened, then in the board minutes, they must extensively record all these situations and, at least make a record. If there is a future change in law, clarification comes, you may have to evidence that these decisions were taken from India because of the situation that was not within your control. Okay, that is possible. And in fact, if you look at Australia and some other countries, you might want to talk about it a little bit later on. But you can go for that. Number two, and I'm not 100% sure of the cuff, that there is also Section 119 2B, under which Central Board of Direct Taxes has a power to grant certain special reliefs when some hardship is caused, and particularly when the hardship is caused to a company because of this situation, there is perhaps a reason for CBDT to intervene. But this would be very helpful when there are large amounts involved. I do not know whether in small cases how much CBDT will involve, but I think irrespective of that, you should have all the records of why these important decisions are taken. And same thing even for individual tax residents, for unexpected reason, they are all stuck here, whether they are foreigners or they are Indians or otherwise, that situation could arise. So important thing these days is your document, how they are drafted, and all that will be seen after 2, 3, 4 years when situation is all right and the tax assessment is taken off. At that point of time, you may have to prove that, this situation existed and, we could not have any other recourse but to do this and stuff like that. I think you might want to talk a little bit about the Australian situation, how they have dealt with, if at all. And so, it is very important that you have a record of the whole thing. And in the US, if you look at tax residency provisions, there are, the tax resident of individual, for example, is dependent on number of days you are in the US, of course, just like India. But there is an exception at times for students, sometimes when they are stuck for sickness, sometimes for other reason. Then there are exceptions. I think our law has not carved out those exceptions. We can emulate something from that side as well. And as far as corporates are concerned, the US tax law is very clear. It's only the incorporation that matters, not place of effective management, not central control and management. So in the US, foreign companies are taxed only if they've effectively connected kind of an income in the US or a permanent establishment. So I think it is very important to document, as I mentioned, the circumstance under which you are stuck, and that may help you to apply for some reliefs. And as soon as possible, you should perhaps even write mail to the finance ministry that this is the reason why we are stuck here. That will be my first response,
Yeah. And I think just one thing to add there, and, Ashish, maybe you should talk about the Australian issue, is that many times we have seen specifically for foreign companies which are investing in India, usually these companies are set up, in the form of LLCs or LPs, limited partnerships. And these are all hybrid entities. Now, India has a very different tax residency rule for corporates and for partnerships. For partnerships, the residency is considered to be based in India, even if part of the control and management is in India. And for corporates, it's the POEM rule that applies. On the face of it, when we look at a limited partnership, it seems to us, based on the nomenclature, that this is a partnership, and so therefore, even if part control and management is in India, it should establish tax residency in India, which is a bigger concern, because then it does not even matter what type of decision you're taking in India. Just by holding one board meeting in India and taking one decision in India for the foreign LP, you could establish residency for the foreign LP in India. However, what should be done for the hybrid entities is that we should not really go by just their nomenclature. India does not really have the concept of hybrid entities as such, and it does not really recognize foreign hybrid entities. The true legal nature of the LPs and the LLCs and the LLPs needs to be looked into carefully to see whether they behave more like corporates or as partnerships. And accordingly, their tax residency should be looked into as per the relevant rules in India. I think that's really important, because we have seen a lot of cases where foreign partnerships have been hauled up for being tax resident in India, whereas in reality, they should be taxed as corporates in India. And if they are taxed as partnerships in India, then anyway, if their key people are sitting in India, then there's a larger tax risk that they are actually sitting on. So Ashish, why don't you talk about what other countries have done? I think that's really relevant, because they have really gone ahead in their thinking and looked at the end of the financial year, and possibly in those countries as well, and taken a long-term view with respect to tax residency.
Thanks, Parul. So I think I'll talk about that. I think that I'll add the question also that is showing on the chat box with respect to somebody being stuck in India with respect having COVID treatment happening. But on that, I think we've seen a number of countries do a number of things on tax breaks, tax incentives that are being given to various individuals, companies, etc. They're deferring taxes, interest penalties, etc. To next year, or are waiving them at times. One very interesting and unique thing that we saw was with respect to Australia. Now, in Australia, they brought about these three changes with respect to whatever is because of the impact of COVID-19. Now, first is with respect to the corporate residence. Now, when a non-Australian incorporated company would be treated as an Australian resident if it carried on business and had its central management and control in Australia. But because this would be the usual situation, right? But now, because of COVID-19, if some of the directors are attending board meetings in Australia and because of COVID, they had to remain back there, then that by itself will not affect that company's residency. So that company will not be considered to be a resident of Australia merely because the director had to stay back and the decisions were taken from Australia because of COVID-19. Similarly, for permanent establishment, right, where if the company would have not otherwise formed a permanent establishment, then by virtue of COVID, if the direct employees, etc., had to remain back in Australia and could not go out, the company will not be considered to be having a permanent establishment. And consequent to these changes, they've also made change with respect to employee tax holding, which says that if an employee of a foreign entity was present in Australia and had to remain back here for the next 3 months, uh, then he will not be considered to be a tax resident of Australia, and therefore the withholding tax obligations which would otherwise have been applicable will not be made applicable to the payer of the employee in Australia. So this is a very interesting and unique a change that is being brought about by Australia, considering the impact of COVID, right? Because people may remain back, people will not be able to travel back to their home countries, decisions will be taken, and this ties in very well with what Nishith was trying to say, that it is in this period that many decisions will be taken by directors which are going to have a significant impact on the way the company is going to grow in this year, and therefore situations such as these are exceptional situations, and the law needs to be modified to take that into account. Now, on the question that has been coming to us on the chat box with respect to is from Siddharth, saying that whether a person having residency in outside India who has been stuck in India due to COVID treatment, so whether this days in India of person having residency of outside India would be considered for calculating his tax residency status. So Siddharth, yes, those days will be counted, and if you did cross the threshold, you would be considered to be a tax resident of India. Uh, there is no exception in the law for treatment in India, and there has nothing been amended up till now. We hope that the government would make some amends, and if people who have stayed back and cannot travel back to their home country because of COVID would not be considered to be tax residents, something similar to what Australia has been doing. But at this moment, there is no change in law, and if you did remain back in India, you would be considered to be a tax resident if you cross the number of days. I think we'll take up any more questions if anyone has.
And I think just a couple of points that I would also be worried about in these times is that if there is a poem that gets established in India, one is transfer pricing will apply. Unfortunately, the way that the law is worded, a foreign company which has a poem in India is still considered to be a foreign company. It does not become an Indian company. And so therefore, all the obligations, responsibilities on a foreign company will apply, and related party transactions of a foreign company with another foreign company will also then get subject to tax in India. And this is a kind of very onerous, maybe not thought through kind of a requirement, because ultimately when a foreign company gets subject to tax on its global income, then the whole basis of transfer pricing, where we are trying to, not erode our tax base, that principle does not really apply. But whatever decisions are being taken in India, one may also have to, be mindful of the transfer pricing impact. And the other impact that also I would be worried about is that the applicability of minimum alternate tax. Currently, foreign companies are not required to pay minimum alternate tax in India, provided they do not have a permanent establishment in India. Now, it is expected that, if a foreign company has a poem in India, then, due to having a place of management in India, it would also have a P in India. And so therefore, MAT would also continue to apply on the foreign company. Although probably, it's not, it may not be so, such a big issue if anyway the foreign company ends up paying tax in India, but the tax rate for a foreign company is still continues to be 40% as compared to an Indian company, which also, where the tax rate could range from 15% to 30% depending on, the election that is made in India. So I would be worried about that. The other thing which one should know is that, if a foreign company distributes dividends to another company, then the dividend should not as such be taxed in India, even though the foreign company has a poem in India. So there are certain minute details which apply to foreign companies that have poem in India, and the taxation is slightly different from Indian companies which are tax resident in India. And, if a poem cannot really be avoided in India, then at least, the taxation of these companies needs to be looked into very carefully to see what amount of liability are we really talking about, and what is the ability to claim foreign tax credits in the home country where this company has been incorporated.
No, that was wonderful. I think you all discussed a number of aspects of the tax residency relating to individuals and the corporations. Unfortunately, as we saw, there is no exception made for this exceptional circumstance, I would say so, in relation to the tax residency. So I think we need to do something about it. As you all know that as far as the tax residency of a foreign company is concerned, is just if it becomes tax resident of India because of poem reasons, even the tax rate goes up. normally the Indian companies are taxed at the rate of 25%, let's say now. But in case of foreign company being deemed to be having become a tax resident of India because of the poem, then it would be taxed at the rate of 40%. I think those situations are also to be borne in mind. So if there is any particular situation, I think please make sure that your documents are in place and you have some reason to go to government and ask for relief. There is no specific relief, but you have a good case to at least discuss. And same thing for individuals who have got stuck into India. It is very important that some representation is made to give some kind of relief. Otherwise, this will create a lot of chaos. And you explained everything very well. I don't want to take too much of time. We are close to the closing. But one thing I would really like India to do is to quickly learn from what other countries are doing and what India should do. I think we can at least help taxpayers in these dire circumstances, and I'm sure that they will do their best. I'm very confident that something would happen, provided they're sensitized and they are explain the circumstances. So I think this is very important. If any one of you have any ideas, please send us. We will be sending out our own recommendations to the finance minister, and we'll be happy to incorporate any of the suggestions that you might have. I would like to close this meeting at this point in time, unless anyone has any specific question. But for the time being, sayonara, goodbye, and good night.